Hello, everyone, and welcome to today's program. You've mastered remote working. Now, what about trade secret protection? My name is Wolf McGavern, and I am one of today's panelists. There are just a few housekeeping matters that we want to talk about before we get started. First, once you've accessed the program, you will find several widgets on your screen. Feel free to explore those throughout the presentation, in addition to the PowerPoint slides that we're showing. I want to call your attention to two widgets in particular. The first is the resource list widget on your right-hand side, which includes a copy of the presentation for you to download and print if you'd like. You also should see a Q&A feature to your left. Please use this widget to submit any questions that you have throughout the presentation. We will try to get to as many questions as we can during the presentation, but that said, if we do not get to your question, we will reach out to you individually to ensure that your question is answered. You will also find a bios widget. You can expand this feature to get additional information about any of the presenters today and their practices. Also, the presentation is being recorded. We will be providing a copy of this recording together with the PowerPoint deck after the presentation has ended. Lastly, if you are seeking CLE credit and provided your bar information when you registered, we will be in touch once credits are approved. Without further ado, I'd like to begin by introducing today's panel. To make sure that we cover our bases on employment law and other topics, we have with us today Megan Madriz and Sabrina Beldner. Megan is a labor and employment partner in our Houston office, and Sabrina is a labor and employment partner in our LA office, also serving locations such as San Francisco. Next, we have Yasser Madriz and Brian Riopel. Yasser is the managing partner in our Houston office in the Business and Securities Litigation Group. Brian is a member of and former chair of our firm's intellectual property department. Now, that's a tough group to follow, but rounding us out today, we have myself and Miles Indest. Miles and I are both associates in the Business and Securities Litigation of McGuireWoods, with Miles in Houston and me up here from Washington, D.C. Today's presentation will proceed in three parts. First, we will provide a high-level overview of trade secret law. Second, we will have a panel discussion of what has changed because of COVID. Third, we are going to give you 20 concrete practice tips to use in 2020 and beyond. With that, I'll turn it over to my colleague, Miles.
Thanks, Wolf. So we're going to start here with Trade Secret Protection 101. The main two questions you should ask yourself are, how do you identify what a trade secret is in your business? And then how do you actually go about protecting those trade secrets? So first, for Trade Secret 101, we're going to answer a few questions. What are trade secrets? Why use trade secrets versus other protective measures, such as patents? We're also going to discuss how can we protect trade secrets? And then what is trade secret misappropriation or theft? So trade secrets are defined differently, whether you're looking at a federal statute or a state statute or common law. The Defend Trade Secrets Act is the federal statute that allows companies and parties to bring claims in federal court for trade secret theft. You'll see that this statute is very broad, and it covers all forms and types of financial, business, engineering information, patterns, plans, compilations. It's intended to be very flexible and cover any sort of information that your company finds value in from being secret. The only main restrictions are that the owner must take reasonable measures to keep it secret, which is a fact-intensive question that we're going to talk about throughout this presentation. And it also must derive value from not being generally known or readily ascertainable through proper means, such as it's not really a trade secret if someone can just look it up online or maybe reverse engineer it. It's got to, your company has to take steps to actually protect it and keep it secret. Wolf here is going to talk about some of the state laws that may apply.
Yeah, that's right, Miles, thanks. So the definition of trade secrets varies by states. Most states follow some version of what's called the UTSA, and I know we're throwing a lot of acronyms at you already, but the UTSA is the Uniform Trade Secret Act. It was initially propagated several decades ago and has been adopted by almost every state, with one notable exception being New York, with a lot of contracts obviously governed by New York law. The UTSA's definition, you might hear referred to sometimes as UTSA, The definition is generally consistent with what Miles described for the Federal Defend Trade Secrets Act. But it's really important to caveat that you want to check to see whether your parallel state law for trade secrets matches the federal definition, or whether the state law actually gives you additional rights or remedies that would make you want to pursue a parallel claim. So in that sense, the phrase uniform Trade Secret Act is a bit of a misnomer because the different states have adopted it in different ways. Just to give one example, the definition of UTSA in some states, of trade secret in some states, includes contact lists and customer lists. That's the case in Texas, Ohio, Connecticut, and Oregon. So key takeaway from this is that you want to check your specific jurisdiction's requirements and definition of trade secret.
And
with that, I'll turn it back over to Miles.
Right, given those statutes that we discussed, the state and federal statutes, it's a strategy call whether you want to file in federal court or state court, but the general requirements overall are 5 key elements. It's information, it's not generally known, it's not readily ascertainable by proper means, and it derives independent value, and you keep reasonable measures to keep it secret.
So one obvious question from the get-go is, so why would you want to rely on trade secrets? After all, there are other ways to protect intellectual property. Obvious things that come to mind are copyright and patents. Well, one reason is that trade secrets allow an owner to maintain the secrecy of the information. This is in stark contrast to patents, which require disclosure. And of course, just because you apply for a patent doesn't mean that it won't be invalidated. Relatedly, the second reason listed here is that trade secrets are extremely flexible. I hope that became clear from our discussion on the definition of trade secret, which was quite broad. Trade secrets can apply both to technical information as well as to information that you might not immediately think of as a trade secret, such as customer lists or other types of non-technical information. And the ability to protect things like customer lists or vendor lists or employee information really makes trade secrets an invaluable tool when it comes to protecting relationships. Another benefit that's not listed on here for trade secrets is that there's no, direct registration costs when it comes to trade secrets. But as Megan and Sabrina are going to tell you in just a moment, that doesn't mean that there aren't things that have to be done early on to protect trade secrets. And with that, I'll hand it over to Sabrina.
Thank you very much. Thank you for joining us everyone. I want to talk a little bit about reasonable precautions and safeguards. When you go to defend either customer lists or some other production process or technical data as a trade secret, you need to be able to show that you have used reasonable precautions and safeguards to maintain that information as a trade secret. So what are the building blocks of that? First and foremost, in terms of employees, you want to make sure you enter into agreements with them to maintain the confidentiality of your data, your processes, your customer lists, your supplier lists, your pricing, and non-disclosure agreements as well. The second important piece of that is you can't protect a trade secret if you're not treating it as a trade secret. So you need to be sure that you're taking appropriate measures to restrict access to the information. You want to make sure that there isn't widespread knowledge of the trade secret to people who don't need to know it or don't need to use it, and that it cannot be readily accessed by just anyone within your organization or externally, and that it's not disclosed as a matter of publicity. If you're listing on your website, for instance, who all of your customers are, you may have an uphill battle protecting a customer list containing those same names. And obviously, you want to control who can get your trade secrets, how they can get it, and one thing we'll talk about as well later in this presentation is how someone can transmit or share or download your trade secrets. And lastly, we encourage our clients who want to protect trade secrets and confidential information to have policies or procedures in place to do so, but those policies and procedures don't help you in trade secret litigation and defending and protecting trade secrets if you don't follow them. So lax enforcement of policies that you have, or inconsistently applying them, or only giving out confidentiality agreements to some employees and not others, may undermine your efforts to protect those trade secrets at a later date. Now, in terms of contracts and onboarding, now this would apply to employees as well as consultants. You need to have non-disclosure agreements, and you want to have non-competition agreements and non-solicitation agreements where you can, but we need to remember that one size does not fit all here in the United States. There's different jurisdictions to consider, particularly if you have employees in many different jurisdictions. California, for instance, views non-compete restrictions and non-solicitation restrictions much more suspiciously than other states, and is very prone to striking them down. So a one-size-fits-all agreement will not necessarily work if you have employees spread out throughout the United States. And also, with that being said, one agreement is not good for forever. The law is consistently changing. Many states are taking it upon themselves to enact different employment laws and more stringent employment laws. So as a best practice, we recommend that folks who have trade secrets that they want to protect have their agreements revisited every few years for legal updates and compliance issues as a good best practice. And with that, I'm going to turn it over to Megan.
Thanks, Sabrina. So Sabrina talked about things that you can do with your employees in terms of the contracts and the policies that you can put in place to protect your trade secrets. But another thing to consider are electronic restrictions. For example, companies should consider including confidentiality labels either in the header or footer of documents or in file names. But this is something that you may want to reserve for particularly sensitive business information. I mean, if you're overusing confidentiality labels for documents that truly just aren't confidential, it's going to take away from the use of that in documents that are. Another thing to consider is encrypting the data. Again, this particularly for very sensitive business information, such as the company's crown jewels of trade secrets, encrypting it to make it harder for both employees within the company and those outside the company to potentially hack it. You may want to consider disabling copying and printing functions on certain documents. That way certain people can't try to walk away with your information by copying it or printing it. You also should consider whether you want to disable employees' ability to install certain programs, such as, for example, employees' ability to back up their company computers to cloud accounts that are not associated with the company. You certainly want to password protect access to the company's electronic systems, such as individuals' laptops, their access to the servers in the network, and access to where certain information is stored. You should also limit employees' access to information. For example, your salespeople likely don't need access to your engineering and design drawings, and your engineering team really doesn't need access to your marketing plans and financials. So companies should look at their employee types. They should segregate where different types of business information are going to be stored and limit access accordingly based on a strictly need to know based on the type of information in the employee's position. You should also consider, and most companies are already doing this, routine password changes. And as annoying as they are to constantly have to change your password to some 10-digit word with a mix of numbers and symbols, it helps to protect your information from getting hacked. And you also should assess your security measures for remote access to your network and servers. And this is a topic that we're going to cover in a few minutes in more detail when we address the impact of COVID-19 on the workplace. So while electronic restrictions are often on the forefront of companies' minds, physical restrictions sometimes get forgotten. And this is particularly true as workplaces move more to less paper or even try to become paperless. But if a company has some of its confidential and proprietary business information, if they're storing it in a hard copy form, it should be locked up. And that's, it can be locked up in a file cabinet, or there could be a certain room where the information is stored with restricted access. And, we've had cases before where the departing employees walked off with paper copies, thousands of copies of confidential information because the access was just wide open. And, this can definitely be true in small offices where there's little management oversight or perhaps, not many restrictions on where the information is kept. So it's always important to consider that employees don't necessarily just steal things electronically. They will walk off with paper copies as well. You should also have adequate restrictions on visitor access, particularly to areas where your trade secrets are located. For example, we had a case where the design of certain equipment in a plant was considered the company's trade secret. And one of the things at issue in that case was how our client restricted third parties' access to the plant floor where the equipment was located. For example, did it require advance permission to visit the premises? Did it escort third parties around? Did it restrict videos and photos? Did it require non-disclosure agreements before allowing third parties to see the equipment? Did it require sign-in and out sheets to track who visited? Those are all things to think about. And, it's important to remember when we talked about what are trade secrets are not just documents and data, but it can be physical items that need physical protections to protect them. Also, another important component to protecting your trade secrets is limiting and monitoring disclosure of the information. And this is particularly true if you're going to share any confidential proprietary information with the third party. In that case, it's really important to have some type of non-disclosure agreement in place to protect the information from being disclosed and restrict its use. And it should also provide for the return or destruction of the information upon the conclusion of the relationship between the two parties. If a company is freely sharing information with customers, vendors, and other third parties without an NDA in place, it's going to really weaken any argument that such information is considered a trade secret. And lastly, companies should have adequate IT tools to monitor activities, such as access logs to its networks or shared drives, flagging of outgoing emails with attachments to personal email domains, or heavy download traffic by a user. Sabrina, what are some considerations for employers when it comes to offboarding employees?
Thanks, Megan. So when you're offboarding an employee who has had access to information that you're concerned about, sensitive information and trade secrets, I think it's important, first and foremost, to remind the employee of their contractual and common law obligation. I can't tell you how many times an employee leaves and doesn't even have a copy of the written contract that they signed in terms of confidentiality. So I think as a good practice, you want to give an employee a copy of what they have signed. It's going to be important also, you may want to know where this employee is going and why. If they are going to a direct competitor and you have significant concerns, that may be something you want to talk about behind the scenes with your legal counsel to discuss and plan and strategize for how you want to handle the situation. When an employee is leaving and they're going to a competitor or you suspect they are, if you have enough lead time while they're still working for you, as Megan mentioned, you do want to be monitoring. If they're still working for you for a few weeks before leaving, you may want to make sure that there isn't a bunch of email traffic, that mass storage devices aren't being plugged into their computer to be used, that they're not accessing things outside the purview of their direct job duties. And if they leave and you have their computer and you have concerns, we strongly recommend you don't put it back in use. I had a client wipe the computer right away and then a week later decide that they were really concerned about what the employee had done, and it was a very difficult forensic analysis to undertake to go back to it. But if you can take the computer out of use for a little while, wait and see what starts happening and not give it out to other employees and maintain a clean chain of custody of it, that can help you in terms of your trade secret defenses and arguments later if you think the employee engaged in any improper conduct. It's very important at the time of exit to ensure that you get a return of all company property and anything that could have trade secrets, and that's obviously, hardware, devices, email, cloud data, and hard copies. Same of removable devices if they're even able to be used with your systems. And one thing we recommend as a best practice is that you have outgoing employees sign a document affirming under oath that they've returned and not retained copies in any medium of any type of confidential information or trade secrets. That way, if you later come to find out that that's false, you can impeach the individual with their prior written representation. Obviously, one of the first things you need to do when someone's leaving is disable access. You don't want them on your network. You don't want them to be able to take things. In terms of wiping their personal devices, that can be a more complicated situation, particularly if they bring their own device and have limited access to company emails or other things through that. And there's also state laws regarding, employees' personal property. So if they're using a personal device, we recommend consulting with counsel and addressing it under applicable laws. And then finally, apply these procedures consistently. Make sure you go through this with all employees who are departing, even those who you think may not be going to a competitor or taking significant information, just so that way you can say that this is a common practice and how you deal with all employees. And now with that, I'm going to turn it over to Yasser to talk about threats to trade secrets.
Thank you, Sabrina. So what are the threats to trade secrets? There's generally two types. There's internal threats and there's external threats. The internal threats obviously include current and former employees. Former employees who have decided to join a competitor for more money or have decided to start a competing venture based on the information that they've amassed during their employment with their former employer. Oftentimes decide to take information with them to give themselves an edge. Even current employees who aren't interested in leaving their current employer sometimes get tempted with bribes from competitors or former friends that decide to start a competing venture also sometimes share information. So those are two obvious threats. I put under internal suppliers, and I didn't put clients, but in reality, those suppliers and clients also can fall under external. Oftentimes companies engage in business relationships with suppliers that are key to their business operations, and sometimes those suppliers have key business relationships and personal relationships with employees that leave the company, and oftentimes when they join a competing venture, those suppliers and sometimes clients want to continue their business relationship with the employee at their new employer as opposed to the former one. So clients can do the same. Clients oftentimes want to get a better deal and decide to follow in a former employer to their new venture. And in doing so, sometimes they share the confidential business information such as price points in violation of the business practices that they had with that company. That is a very good point that stresses what Sabrina and Megan were talking about, which is the need to actually make sure that the company is covering its bases by having the applicable agreements that protect from such disclosures, such as NDAs with those suppliers and clients. With respect to external threats, those include competitors, obviously, but also hackers and cyber attackers. There's people that dedicate their lives to stealing information that they can sell off to the highest bidder. There's also governments that have platoons of very sophisticated hackers that do nothing but actually try to infiltrate a business's network to get key information. We saw that, for instance, when the North Korean government was able to infiltrate Sony. So what are the four? So what is a misappropriation, legally speaking? The UTSA and the DTSA define it as an acquisition by a person who knows or has reason to know that the trade secret was acquired by improper means. The DTSA also includes disclosure or use without consent by a person who used improper means to acquire them, or knew or had reason to know the information was derived from one who used improper means to acquire it, acquired subject to a duty to maintain secrecy or limit use, or derived from one who owed a duty to maintain secrecy or limit use. So this is very important because under the prior common law, the standard was not a model of clarity. Generally speaking, improper means were defined as acts that were below the generally accepted standards of commercial morality and reasonable conduct, and that led to case law that was just very amorphous and very vague. The statutes now define it a lot more specifically. Improper means is defined more narrowly and specifically and includes theft, bribery, misrepresentation, breach or inducement of a breach of a duty to maintain secrecy, to limit use or to prohibit discovery of a trade secret or espionage through electronic or other means. More importantly, or equally as importantly, I should say, proper means is defined as discovery by independent development, reverse engineering, unless prohibited or any other means that is not proper. So that's pretty clear that anything that results in someone that is not a trade secret owner having access or the ability to use or disclose a trade secret that belongs to another by any means, by independent creation of that trade secret is probably not legal. So what are the common types of trade secret lawsuits? There obviously is an employer against its former employee. This is a very common case when the economy is very hot and it's booming. Competitors want to hire the employees of its competitors that have those key relationships in hopes that if they hire them, they'll be able to bring those business contacts to them. And when there's an economic downturn, there's mass layoffs, and those employees try to use those connections to get a new employment with a competitor. I'll skip down to bullet point number 3 because it's related, and that's an employer versus its former employee and the business B, which is the new employer of the former employee. And that's related to number 1. And it's important to say that there are strategic reasons as to why a company may want to only sue the former employee and leave the new employer out of the lawsuit. Obviously, if you include the new employer, then it's going to present a more vigorous defense. Another thing is that by including the new employer in the lawsuit, you're automatically alleging that they engage in wrongdoing, which may or may not be the case. And by going against the former employee alone, sometimes you have a situation where the new employer is actually ignorant to the fact that the employee they just hired took illegally information with them from its former employer. So it's not always the case. It's often not the case, but something I should mention that you should think about before you should consider before deciding which parties to name in the lawsuit. The third type of case is one business against another. There are instances where a competitor gets trade secret information by other means that do not include an employee, and such as by getting information from a client or a vendor of its competitor. And one other type of trade secret lawsuit that I neglected to include in here, and it's becoming a lot more popular, is actions by the U.S. government against individuals who have engaged in trade secret theft. It's becoming a lot more common right now. Governments are becoming a lot more accepting of the incredible value that their government's companies have in the form of trade secrets, and they're being a lot more aggressive about protecting those trade secrets. One example is the U.S. government's lawsuit against Huawei, where U.S. prosecutors say that Huawei had a policy in place that gave bonuses to employees who successfully stole confidential information from competitors. So something to keep in mind. So what is the process of a trade secret action? There's obviously the investigation. Then if it is found that a trade secret theft actually does occur, there's the filing of the lawsuit. And of the pursuit of a temporary restraining order because of the value of trade secrets and the possibility of irreparable harm by virtue of a competitor improperly using a trade secret. Most trade secret plaintiffs want an injunction issued that precludes the defendants from continuing to use the trade secret at issue until the trial. Then the temporary restraining order is only for a limited scope of time, so you'll have a temporary injunction where you'll have essentially a bench trial on the merits of the case, and then obviously a trial, and you hope that you win. But out of the 4 phases, I submit to you that the most important phase is the first one, and that's conduct an investigation. It's so important. There's so often the aggrieved party is very aggressive about wanting to initiate lawsuit as soon as possible, but it's so important to do your due diligence and get your evidence in hand. That way that you can present a very colorful story to the court and create a very good narrative about the actual wrongdoing that took place. The more surreptitious the picture that you can paint, the more likely that court's going to be sympathetic with your cause of action. Lastly, the one thing I want to mention is that historically, some states require plaintiffs to not only show that trade secrets had been stolen, but to also prove that trade secrets were actually used. And absent of showing that the actual use of a stolen trade secret, sometimes courts would be reluctant to issue a temporary injunction to protect the plaintiff until trial. This is not necessarily the case anymore. A lot of states have what's called the inevitable disclosure doctrine, which states that if an employee has innate knowledge of a trade secret and he joins a competing company, then by virtue of his innate knowledge of that information, it will be assumed that it will be inevitable that he will use it for the benefit of the new employer. These concepts have actually been incorporated in both the statutes that we're talking about today, because they provide that it can be actual or threatened misappropriation that can be enjoined. With that, I'll go ahead and pass it over to Brian.
Thanks, Yasser, and thanks everyone for joining us, especially during these crazy times. I'm just going to cover in a couple of minutes the recovery of damages in trade secret cases. And there are several measurements available in a trade secret case. The first is actual loss. And actual loss is something measured by, for example, if you lost sales because a competitor stole your trade secrets, or you've lost customers, you can measure those, and they're the actual loss to the plaintiff. Unjust enrichment is a broader concept and usually is measured by how the defendant was enriched as opposed to how the plaintiff was damaged. And you can be creative in determining what unjust enrichment is. And for example, in a case that I had, which I think will be on the next slide here, we were representing a plaintiff, and we caught the defendant fairly quickly before they could really affect the sales of our client's product. And so what we did is we went for unjust enrichment, and we had to figure out how to measure that unjust enrichment. And because the defendant was a foreign company, we're having a hard time measuring it. So what we did is we determined how much it cost us, the plaintiff, an investment to develop those trade secrets, and then use that as the unjust enrichment measurement for what the defendant avoided by not having to make that same investment. And so that's one way you can do that. The third category is reasonable royalty. This is a concept that was borrowed by the drafters of the Uniform Trade Secret Act from patent law. I have to confess, I haven't seen a lot of trade secret cases, or I haven't been involved in a lot of trade secret cases that use reasonable royalty. And I think one of the questions that would happen here is over the last, I would say, 10 years in the area of patent law, especially from cases coming down from the Federal Circuit, they've really clamped down on how you can recover reasonable royalty and how you have to measure it. It would be interesting to see if some of that case law is brought over into the trade secret area if a plaintiff was seeking a reasonable royalty. Now, the last thing you see on the slide is there are exemplary damages or punitive damages, or however you want to do them, and they're usually measured as a multiplier of the compensation award. But to echo some of my fellow panelists' comments, this is something that you really need to look at the state statutes and not just the state trade secret statutes, because, for example, in Virginia, where I reside, there is a cap on punitive damages. So in one case in which we got a very large exemplary damage award, it was capped at $350,000 because that's the cap on punitive damages in the state Commonwealth of Virginia. The next screen here is just the example of some of the, how trade secrets can be so valuable. The case I referred to earlier is the DuPont versus Cologne case, in which I had the privilege of being the lead trial counsel in that case. And that $920 million award was the one I was referring to that was measured by the amount of investment that DuPont had put into developing Kevlar and the manufacturing of Kevlar. And I literally could talk the whole hour about just that case. It was such a crazy case. The last thing I was going to cover on here is the recovery of attorney's fees. Many of the statutes allow for the recovery of attorney's fees if there was misappropriation and bad faith. The one practice tip I would give both to outside lawyers but also in-house counsel on this is that if you're doing a trade secret case, sometimes there are other claims in that case too. You may have like an unfair competition or something under a state law. It is important to log your time separately so that you can easily capture the attorney's fees, because you'll have to make a motion for attorney's fees at the end, and the courts, especially federal courts, will peruse those very carefully to make sure that you're not going beyond the trade secret claims and trying to capture, for example, breach of contract claims or something like that in your attorney's fees. And with that, I will pass it on to Miles.
Thank you, Brian. So now we're going to discuss why y'all are all really here and why most of y'all are probably working from home right now or working remotely. The COVID-19 pandemic, we all know how it's impacted us and our companies. Obviously, it's revolutionized the way that we work from home and how companies transfer their information and documents. Some companies have just completely changed their policies on the issue. Zillow's chief people officer recently said, our bias against working from home has been completely exploded. Zillow used to have 2% of its employees working remotely full-time, and recently they announced that all 5,000 employees could work remotely from home until 2021. And then Twitter, Google, Facebook, all these companies have also announced work from home policies, some going as far as to say if the role permits and the employee wants to, they can work from home forever. So now we're going to just discuss some pandemic-related questions that you should be discussing with your clients and with the company to make sure you know what to expect over the next few years or if the pandemic continues for several more months. So the first question, this will be, we'll talk to each panel member separately. This one's for Sabrina. Will remote working be the new norm for the future?
Thank you, Miles. I think I can sum it up in one sentence by saying it'll be very difficult for us to return to how it used to be. As Miles alluded to, this pandemic has really opened people's eyes to work from home. And companies that used to have a bias against working from home and fears of inefficiencies and inattention by their employees while they are working from home, that's largely been disproven as the workforce has had to very quickly shift to a work from home status during this pandemic. And as we need to go back into the workforce, we're not going to be able to go at 100% because of social distancing, because of certain people's fears, because of various things like school and childcare needs that will still require people to be remote. And I think what we're going to see is we're going to see a shift in attitude by companies who realize that there's a tremendous savings in work from home. There's not just a cost savings, but for people who work in very populous areas and have long commutes, that's a time savings that results in an improved work-life balance and better employee morale that definitely need to be considered. And on top of that, when more people are working from home, you need less office space, and the real estate, which is a very critical and significant expense for employers, becomes something that you can use as a cost savings. And lastly, while we can't be sure, but the fear of a second wave or an actual second wave may keep people working from home for longer than we expect, and I think companies will certainly use this to plan for the future for transitioning to work from home in case of other, critical needs or reasons that might come up.
Those are some great points, and talking about coming back to the office, some companies are going to institute staggered policies, and that kind of goes back to what Megan was talking about, where when you classify different employees, how they receive confidential information, companies should consider when staggered employees are coming in and which ones are working remotely full-time and part-time, how to categorize those employees and how they receive confidential information. So next question will be for Yasser. Did stay-at-home orders affect the exchange and storage of documents for companies?
No question. It's really interesting because shelter-at-home orders are effectively telling companies to do the exact opposite of what their lawyers have recommended for years to protect their trade secrets. Lawyers are always telling their clients to keep their trade secrets protected by confining them on company grounds, and in that vein, they recommend that companies prohibit trade secrets from leaving company premises. Here, shelter-at-home orders are forcing companies to relax those rules and give employees remote access to trade secret information. Obviously, that subjects trade secrets to potential dangers. Putting aside the obvious risk of trade secret theft by employees, there are significant dangers associated with remote access because it necessarily relies on the exchange and transfer of information and data, typically over the internet, which makes trade secret vulnerable to cyber attacks. So this has forced companies to get really creative. Some of the precautionary measures that we're recommending to clients include, we're recommending that clients reevaluate which employees absolutely require remote access to trade secrets. I know that each company that has trade secrets hopefully is already doing that, and they have an identifiable, hopefully small list of people that have access to trade secrets. Well, we're encouraging them to make that, to whittle down that list even further. The less people that are, the less people that have access to that information, the less susceptible that information is going to be to potential theft. Another recommendation is that we actually, that companies stress test, that's what I call it, stress test an employee's home for vulnerabilities. If a company decides that a particular employee it's critical for that employee to have access remotely to trade secrets, make sure that somebody in the IT department goes to that home and performs an audit and stress test that employee's home network, so that they determine the type of internet that they have, the firewalls and other protective software that they have to guard against cyber attacks. But in addition to networks, also other devices, such as Ring cameras, Alexa, that can be used for eavesdropping. We recently heard that Ring actually got hacked. You'd be surprised how easy it is for somebody to succeed in gaining access to a Ring camera to be able to actually go and review footage or of somebody like looking over their computer, and they can get access to confidential information, bank accounts. So that's some of the risk of today's technological advancements. Another suggestion is that clients consider making software upgrades, particularly in the context of logging capabilities that chronicle when an employee accesses a trade secret, for how long and what was done to it. So if you're going to give an employee remote access to trade secrets, at least consider upgrading your software that gives you an opportunity to see in real time what that employee is doing with the software. And some software even gives you red flags when they suspect that something is happening that could be unlawful to that information. Another idea is to prohibit remote access via the internet and instead allowing access only through external devices. Some company, to the extent that a company is considering doing this, our recommendation is that they have to be, the trade secrets have to be stored on company-issued storage devices as opposed to storage devices that belong to the employee. There's a whole number of dangers of allowing employees to store confidential information on their own devices. And to the extent that a company does that, it's very important for the company to encrypt that external storage device and for them to keep track of the serial number of that storage device, because the serial number will become very useful in the event that theft takes place for purposes of conducting a forensic analysis by a forensic expert and seeing where that device was plugged in and what documents were stored on it. It just allows you to be able to readily identify it. And lastly, some clients are actually prohibiting remote access altogether. With states starting to reopen, this may be less of an issue than at the onset of the pandemic, but at the onset, we saw companies assessing whether they qualified as an essential business so they could allow some of their employees who absolutely needed access to trade secrets onto the premises. So do these preventative measures provide 100% protection to a company's trade secret? Of course not. But it's important to remember that the law only requires trade secret owners to implement reasonable safeguards to protect their trade secrets. Brian will talk about it in a minute, so I won't get into it, but it's going to be really interesting to see if and how COVID impacts how courts view what measures are reasonable in light of the COVID-19 world that we're living in right now.
Thanks, Yasser. That was very insightful. And we'll have to move on to the next one, which is, has the pandemic affected employee turnover? And we'll talk to Megan about this one.
Thanks, Miles. Yeah, I mean, no doubt the pandemic has affected employee turnover. I mean, many employees are on furlough waiting to either be called back or terminated. Obviously, there's been a lot of employee terminations just because of the economic conditions of businesses. And during this time, particularly while employees are on furlough, some employees may be amassing key information to help them succeed should they be terminated or have to find work with a new competitor. Or you could have current employees desperate to improve their sales productivity or to show their worth to their employer, and they may be more inclined to rely on information that they took from their former employer that they put away. They weren't planning on using it, but maybe now the situation has changed and they're desperate. I mean, the point is that during these uncertain economic times caused by the COVID-19 pandemic, some employees are just going to be desperate to get ahead, and that can translate into them, stealing company documents, files, information, and other property. And employers need to be aware of that threat and be vigilant by all of the different ideas and topics that we've been discussing thus far today.
Well, and I think that transitions well into the next question, which is, Will disgruntled or desperate employees use trade secrets for a competitor? Wolf?
Yeah, so thanks for that, Miles. It's definitely something to keep an eye out for. I mean, obviously, as you also mentioned earlier, former employees are one of the types of parties that are most often accused of misappropriating trade secrets, and that can be a high-level employee or it could be a low-level employee. I think what's going to make this situation interesting is that whereas in boom times, an employee might leave and directly work for a competitor, in those cases, it might be quite obvious that they've taken trade secrets with them. You might lose a client the next day, and where you know that the only way that happened was if trade secrets have been misappropriated. Now companies might be dealing with a tough issue of people no longer working for them and maybe not finding other employment in their field for months or longer. So it's going to be a new challenge because obviously evidence does get stale. And one way to prevent that evidence from getting stale is to make sure you're doing thorough processes and investigations when employees leave.
All right, thanks, Wolf. And one of the most important questions now we'll leave for Brian, and that's, are trade secrets still safeguarded and enforced?
Thanks, Miles. You know, I want to echo a lot of the things that Yasser said. I mean, under this current COVID-19 crisis, we are absolutely, or things are being done that courts have in the past found to show that trade secrets were not being adequately or reasonably protected by the employer. For example, you know that people are using personal computers and downloading company information onto their personal computers. There's case law out there that says that's not adequate protection of a trade secret. But is that something that's necessary during this time of everyone remote working? People are probably printing trade documents that contain trade secrets at home. Is that adequate protection? And one of the things is I'll bet you that there are people who, once they finish with the document, they just put it into a trash can. Whereas I'm sure many of the people that are on this call right now are aware that, you know, you should have shredders and things to get rid of, and that's courts have identified that as inadequate. So the question is going to become, for cases that are filed either during the trade secrets, during the COVID-19 crisis, or that rely on activities that happened during the COVID-19 crisis, how are the courts going to treat the reasonable protection question? Are they going to relax the standards for any cases that occurred during the COVID-19 crisis? And here's one example that'll be interesting. Zoom is something that's obviously become extremely popular during the COVID-19. However, Zoom certainly was identified as having confidentiality issues and security issues, and I'm aware of several companies that won't allow communications through Zoom for that very reason. If somebody lost a trade secret through Zoom, is that going to be deemed to be reasonable? I think the courts are going to take reasonableness in context of what happened during COVID-19, but I think it's something that's going to have to be just dealt with later.
Thank you, Brian. That'll definitely be interesting to see how the courts play out. So everybody, we've provided a lot of information to y'all today. So now what we want to do is just provide 20 practice tips for 2020, and this will help you understand exactly why and exactly what you need to do to protect your trade secrets. So we separated it out by a few different categories. Steps 1 through 5 to mitigate risk are to review policies and procedures. Steps 6 through 10 are to manage your employees and turnover. Steps 11 through 15 are lessons learned from the pandemic, and we've discussed a few of those already. And the final steps, 16 through 20, are how to assess your litigation strategies. So we'll start with steps 1 through 5, and I'll hand it over to Sabrina.
Thanks so much. As we're nearing the end of the presentation, I'm just going to run through these quickly since you all will be receiving the deck, and that way we can leave some time for questions. The first 5 steps are important. They're sort of the building blocks of mitigating risk. First, you need to identify and restrict information that's confidential. Make sure it's limited to those who need to know. You need to make sure you review and develop policies and procedures and update those policies and procedures relating to confidential information for the remote working environment, okay, including computer access, bring your own device use, communications, cybersecurity, and social media policies. Review, develop, and update your employment contracts to ensure sufficient confidentiality obligations on employees that will survive the termination of their employment. And upon termination, you want to follow detailed steps to make sure that the obligations are enforced with respect to the employees departing, that they've been prohibited from uploading company information, they've returned everything to you, and they've represented as much. You also want to review and develop policies and procedures related to employee exits and personnel files. One important point on personnel files is when an employee signs an agreement, the whole of the agreement should be placed in the personnel file, not just the signature page. It may often be that the employee signed a confidentiality agreement 2 versions ago, and we don't know that because the whole document's not in that personnel file, and then you can't locate the one that he or she historically signed. So it's very important to keep the whole document, make sure the employer signs it as well if there is a line for the employer's signature. And lastly, in my section, make sure you review and develop policies and procedures that require third parties to sign confidentiality agreements and ensure this process can be continued during remote work. And I think Megan talked earlier about who those third parties could be. So with that, I'm going to turn it over to Megan.
Thanks, Sabrina. So steps 6 through 10 deal with managing your employees and turnover. So it's important to make sure that you train your current employees on their obligations with respect to confidentiality. You also want to make sure that they're signing any acknowledgments on confidentiality policies or policies designed with respect to technology, perhaps use of social media, anything that touches on where information could be disclosed in some type of way. You also want to require use of only company-approved technology. And of course, we talked about during this time there might be employees using personal devices. And if that's the case, there needs to be proper tracking of that to make sure companies have a hold on that and know what's being used and are properly protecting their trade secrets if to the extent anything is being used on something that's not a company-issued technology. You also should require any termination, or if you're furloughing someone, a furlough letter to remind them of their obligations to the company, whether they're under common law or under certain agreements or policies that the employee has signed or acknowledged. And lastly, we talked about this already, but when an employee is leaving the company, you want to assess whether, what information they've accessed and if they've taken anything with them in terms of, thumb drives being inserted, perhaps documents being mass downloaded before their departure. And so with that, steps, I'll turn that over to Yasser.
Thank you, Megan. So now we're going to talk about steps 11 to 15, talk about the lessons that we were learning from the pandemic. Well, the first one would be develop and implement an information protection policy tailored to remote work. I can't stress enough how important it is to get your Chief Information Officer or Chief Technology Officer involved in this process. A decade, or maybe a decade and a half ago, it was very common for lawyers to do this alone with maybe even HR or the legal department. Now technology is such, it's so complicated, and there's so many ways that can lead to vulnerabilities. It's really important that the CTO or the CIO of a company participate in this process to develop a bulletproof or a more secure policy that will protect the company. Number 12 is track and monitor your trade secrets received by remote employees and affiliates. As we talked about, there's software out there that specifically chronicles who is accessing the information, what's done to the information, whether the information was emailed or saved anywhere else, to the extent that's even a possibility. Very important, very useful. It provides real-time information about what is being done or how your trade secret information is being handled. Number 13 is include detailed obligations in employment agreements related to procedure on termination. Megan just talked about that. Very important. Highly recommend something that we mentioned earlier, to the extent your exit procedures do not already have an acknowledgement that has to be signed by the departing employee stating that they're not taking in any confidential information, and that they understand that all confidential information belongs to the company under penalty of perjury. You should do so. I also recommend, assuming that it's allowed in your state, asking them if they to put in writing whether they intend on going to a competitor or start a competing venture. That can be used if it turns out to be untrue. That can be used against them in a trial or in a lawsuit. Number 14 is conduct an annual employee training via webinars and online resources. And this is designed, and it's absolutely necessary for a company to establish a culture of compliance and enforcement. And educating your employees about the policies and what is allowed and is not allowed is very important for purposes of reminding them what they can and cannot do, but also in the event that an employee and their goes to a competitor and they engage in wrongful behavior, this information can be used against them during the trial and very effectively. And lastly, stay updated. Technology is advancing very quickly, and it's very important to reevaluate your protective mechanisms on an annual basis. And with that, I will turn it over to Brian.
So I know we've gone a little over time, so I am not going to go through all of these. I'm just going to highlight a couple quick points. First of all, identify the trade secrets. That is key for litigation because it is always a constant tension between a plaintiff and defendant of whether the trade secrets have been adequately defined. And there is plenty of case law out there that says that a plaintiff can't proceed unless they have adequately defined their trade secrets. So that is something that needs to be looked at and done. The other thing I would say is it's very important to outline the reasonable measures, because that is one of the first things the defendant is going to attack, is to say you didn't protect your trade secrets adequately enough. And the last point I would raise is, do you want to, and Yasser talked about this earlier, do you want to seek an injunction? Injunctions, you want to make sure you have enough of the evidence so that you can convince the court on the higher standard that you're entitled to an injunction, but that it can often stop a case short if you win that injunction and save your client money. And so at this point, I'm going to skip the next slide, and Wolf, just turn it over to you.
Thanks, Brian. Well, we're a little bit over, and it's maybe fortunate because of that we didn't get any questions, but I'd like to thank everybody for attending from wherever you're calling your office today. Please remember that you can download these materials, and this has been recorded and will be sent out to you. If you have any questions on any of the topics raised that weren't covered, please reach out to any of the presenters today. Thank you all very much. This is the end of today's presentation.